Good morning, we're on record. Good morning, good afternoon. Good afternoon, we're on record at 3PA-24-00350CR. Before we go forward any further, Mr. Lawler, please come remove this device. You did not ask the court permission to enter the well. It's my courtroom, not hers.
She said she was going to let you know about it.
She did, which is why I'm asking you to remove it. You can get the same recording all other defendants are entitled to. And you can record from there. Alright, now is the time scheduled for a continued pretrial conference. We have Ms. Corliss here for Ms. Markson on behalf of the state, and we have Mr. Stepovich here for Mr. Rolfe on behalf of the defendant. First, I want to note that we are starting very late because neither attorney called in for the hearing, which has been on the calendar for quite some time. Ms. Corliss, do you know why nobody called in on a timely manner?
Judge, Ms. Markson is on vacation, and I think that we were not aware that this was on the court's calendar today. It's been very difficult for us to track it with it being in Anchorage. My apologies to Your Honor, to Mr. Stepovich, and to the defendant, Your Honor.
All right, Mr. Stepovich, why didn't you or Ms. Rolfe call in a timely manner?
Mea culpa, Your Honor. I thought it was a 4:15. I don't know why I did that. My secretary came back and I called immediately, and I was on hold for a little while, but I apologize.
All right, well,
to the parties.
I know this is hard for, we've talked about it before, Ms. Corliss, but the Palmer Court needs to have, the Palmer DA's office, if they want to pursue this matter, needs to make sure it stays on their calendar, because this is not the first or the second or even think the third time that we've had to call your office.
Yes, Your Honor, and I will pass that on to DA Sears.
Okay. Where are we at right now, Ms. Corliss? I don't know if you even have any notes from Ms. Markson. Are we ready to schedule this for trial?
Judge, what I'm showing, the issue last time was discovery, and I see that since I believe we sent discovery on the very 2 days after that last hearing, I guess I would defer to Mr. Stepovich to see if he has everything he needs at this time.
Mr. Stepovich?
Your Honor, my notes from Ms. Rolfe, who's out of town, we did receive discovery, reviewing it, doesn't appear to be complete. She is composing an email to the Palmer District Attorney's Office for the missing material she's observing. Should be out Friday or Monday. And if there's some issue with, after discussing with them, then she can appropriately petition the court. We're requesting it need to be set back on in about, we're going to say 60 days. If discovered issues have been resolved, we can set it for trial at that time.
Have you conferred with your client about waiving time?
That I have not, and if the time is going to be held against us, if it's a discover issue from the state, that would be one argument. I'd have to discuss him as far as, do the parties have a Rule 45 date, or does the court carry one in its file?
So, I don't know if you have the records open, Ms. Markson. I don't have it open in front of me. I think we're at 60-something days. I can open it. Do you have it there, Ms. Corliss?
So, Your Honor, I'm looking now to see if that is noted in here. And I don't see that that's noted in what I have access to at the moment.
All right, I'm trying to open my computer, which should tell me, but of course it's taking its sweet time.
And I'll keep looking as well, Judge. There appears to have been a motion to stay at one point. I don't know if that was granted, so, and it will probably require some calculation on my part, with more information before I can definitively say, Your Honor.
64 days, oh, you have, that should remind it. According to the court's record, 64 days of rent.
And I don't know if Your Honor wants me to name or Mr. Steppovich is still.
Well, is it okay if I inquire your client, Mr. Steppovich, on whether or not he's willing to waive time?
Yes, and the other issue is if we set it on for 30 days as opposed, we'd be at the 90-day. If there's a motion, of course, that would toll any time. I think it's important that discovery be complete for his due process rights. I don't know if a subpoena was issued or not. If there is, we will withdraw it if we can get the discovery we need. But yes, Your Honor, I don't. You can inquire of him if he's willing to waive it up till I guess up for an additional 60 days. Thank you.
So all you're willing to, we've talked about Rule 45 before. I
So
can't
this
give you
goes
advice,
back to
your
the
attorney's
subpoena
advice.
that filed against the DA, and I mentioned it to the court that the DA was withholding evidence, and obviously there's still withholding evidence from my attorney. I think this is inappropriate for the DA. I really don't want to, I want to get this going.
If there's stuff that, I mean, you need to talk about this with your attorney, but if there's stuff you think they have that they have not given you, then I need a motion, or there's not much I can do about it.
Okay. Yeah, there's items that have evidence numbers and they're not there, so there's stuff missing. And that's what my lawyer is obviously talking about. So I guess I need to talk to my lawyer, or we need to, I've mentioned this before, that I don't have all the information that the DA has. And now my lawyer seems to be having the same problem. So it's like, I brought this up, I served him a subpoena, I know I didn't do it correctly with the subpoena, there should have been a motion to compel, but still, we're still at issues with discovery. This is a problem.
So, my understanding from what I heard from your attorney is your attorney has not yet told the other side what they think is missing. So, I don't know what the holdup is.
That's accurate, Your Honor.
If you're not willing to waive time, then I'm gonna put this on a real short clock, and we're gonna come back together again shortly to figure out what's going on, and if a motion's gonna be filed, which might hold time.
I don't wanna wait another 60 days.
Okay, 30 days?
Okay, yeah. 30 puts it at 94. The court, I don't know how the court's
If we're
calendar
going,
is.
he's agreeing to toll time. If he's not tolling time, we're coming back together
Okay.
next week. So if he's agreeing to toll time for the next 30 days, I will continue it out 30 days. If he's not agreeing to toll time, then we're putting it on next week, and we're figuring out when Miss Markson's back and figuring out what's going on.
Okay, Mr. Lauer, I think 30 days, if we have to file a motion to compel, that will toll the time. So if we toll 30, come back, and the discovery's not there, if we have to file a motion to compel, then it's gonna be automatically tolled under the 120-day rule. I would suggest we toll it for 30 days, no more. Give us opportunity to thoroughly go through this. The motion has to be compelled, and then it's gonna eat time that's against us anyway. But we're still within the 120 days, but 30 days, it makes it a 150-day rule. So I would suggest we toll it for the 30 days, come back, make sure we have all the material we need. If we don't, we will, by motions, that's how you talk to the court. The court cannot do anything unless people, do it properly, and that's the way it has to go.
Well, I get that.
Thank you.
This thing, on the 20th of this month will be a year. So I'm sure that the court and my counsel can understand my frustration, and I wanna get this
I
done.
think Ms. Lawler, we've come together many
So,
times.
I know. And I've made it clear that I just wanna get this rolling. I'll do 30 days, but we need to put a stop to this, and we need to get the discovery dealt with.
Mr. Steppovich, Mr. Rolfe needs to tell Ms. Markson exactly what's missing, and if anything's missing, Ms. Corliss, Ms. Markson needs to get it over. I don't disagree with Mr. Lawler. was a short incident. I don't understand how it could be that hard to get over all the relevant discovery.
It's ridiculous, to be honest.
So,
And Judge, if we could let, Mr. Stepovich could let the assigned attorney know to copy me as well on any type of an email. We are very short-handed here in Palmer. We are doing a number of trials in the next month, and Ms. Markson is part of that when she does get back. So just to make sure that other eyes are getting the emails on this case as well, so that we don't end up in the situation missing a hearing or missing a discovery deadline, would be appreciated if Mr. Stepovich could relay that to the assigned attorney.
can you provide her the email?
Will do, counsel.
Do you have her email address?
Thank you.
We will get her email. We don't have to, we will make sure she gets a copy though. The Palmer office herself and, Ms. Marchson, there'll be a three-way push there.
Thank you.
Alright, well, let's start looking for a time to come together in about 30 days. So, 30 days gets us to.
Your Honor, if I may, I actually, the subpoena, it has a list of everything that's missing.
Well,
I
your
know.
attorney
I
needs to
just-
get, so get, make
Oh,
sure
I
your
will
attorney gets
relay
that.
that.
Get
I'm
that
just
to your
saying,
I'll
attorney.
relay that to
I
them.
found that on the record.
Okay.
Thank you.
So. Alright, how about March 17th, that's actually, I think, 32 days, are you willing to wait 32 days, Mr. Lawler?
I'm fine with that.
At 2 p.m.
Sounds like St. Patrick's Day.
We'll, all eat something green later that day. Alright, that work for both parties?
Thank you, Your Honor.
Yes, sir.
Thank you, counsel.
That is where we'll put it.
Thank you.
Alright, anything else to address today?
Your Honor, would that be 4 o'clock? I just want to be
2
sure.
o'clock, 2 o'clock,
2 o'clock, thank you.
2 o'clock on Monday, the 17th. Alright, Ms. Corliss, anything else to address today?
No, Your Honor, thank you, and again, my apologies that we were late.
I'm sorry I was particularly persnickety, it's been a day,
No issue, Your Honor. Thank you.
Thank you for getting on promptly when we called. Anything else for today, Mr. Stepovich?
No, Your Honor, thank you, counsel.
Alright, parties may be excused, have a good afternoon.
Be excused.
See you, Mr. Wallner.
Thank you.
Thank you.
Can I ask about the press pass real quick?
You will not guarantee an answer, but you
I
can ask.
I would like to set it up over there so I can see my
I
face.
do not let anybody set it up over there, I don't let ABN set it over there, I don't let this, it's security issue, I do not let anybody set it up in different.
Okay, because normally when I do this, that's where I usually set up.
Well, we don't normally do it in my
I
courtroom,
know.
I do not let anybody set up over
That's
there.
why I'm asking you.
No, well,
I just noticed. it's not-
I'm not meaning to be flippant, but, I do not let anybody set it over there,
I know
everybody has
it's
to set
not
it
on
over the law.
the restrictions aren't on here about that, so.
It says the courtroom, it doesn't say you have free reign in the courtroom. You
Yeah.
are being permitted to record in the courtroom, that doesn't mean you get free reign of.
No, it's just clarifying.
If you wanted to put something here, you should write that in, and the other,
Okay.
okay?
I'll file another one. Thank you.
You can file it, but I'll tell you, I'm not going to let anything in the wall. I'm just
My
gonna
camera
tell
over
you.
there, I can't put my camera over there.
No, we
Little
can't put
cherry bar.
anything any further in front of the.
Okay, that's my
Okay,
question.
well, you can file it if you want the record, but I can tell you, I've never let anybody else do it, I'm not gonna start now.
Okay.
Okay?
So the mainstream media can't do it either?
Nope. They stay out, they don't even get to the council table, they stay behind the gate.
Okay, thank you.